Please the court, opposing counsel. My name is Jeff Nielsen. I am here today representing Sue Sheff, the respondent in this case. Sue Sheff respectfully asks this court to reverse the trial court's decision for personal jurisdiction and affirm the trial court's decision in relation to the ADA Title III in regards to the place of public accommodation. In respect to the first question, that matter of personal jurisdiction, Sue Sheff believes that the trial court erred in asserting personal jurisdiction over them for four key reasons. The first has to do with purposefully directed contacts within the forum state. Traditionally, courts have held that a non-resident defendant must purposely direct his activities or transaction with the forum state and perform an act of which he avails himself to the privilege or protections of that state. In the case at hand, Sue Sheff did not avail themselves to the protection of the state of Franklin. Their activities conducted within the state of Franklin were cursory at best regarding advertisements that were not even specifically directed to the state itself. There is no corporate office or place of business that Sue Sheff has within the state of Franklin. There are no offices, and they do not conduct directed sales activities within the state. Any activities that exist within Franklin are simply available for the residents and citizens of Franklin to simply view in a passive way, and Sue Sheff does not direct contacts at them.
Excuse me.
Yep.
Do you believe that society should interpret its laws to account for technological advancements?
Certainly, thank you for the question. Under certain circumstances, of course, but if you're talking about in regards to which framework to apply to this case, I would suggest maintaining the traditional framework and not abandoning it for a new internet-specific test. This is because that despite the internet being an important innovation, it is not an innovation unlike something we haven't seen before. For example, we can look at something like the airplane and the dramatic impact that would have had on interstate commerce, goods being able to go completely across the country in a matter of hours rather than days or weeks, and the court did not see fit to establish a new test during that era, or cars or Amazon or anything like that. The internet is just one of many technological advances that have come and that will come, and the rule of law as is capable of withholding those. Thank you very much. Continuing on with regards to the second point, that the injury does not specifically arise out of the contacts within the state. Even if you were willing to say that the contacts within Franklin were purposely directed, you could not make the nexus that the courts require to show that the actions were the cause of the injury that was from the respondent Sue Sheff's activity within the state. Sue Sheff engaged in advertisements within the state at best, and the injuries that we're looking at potentially arising came out of activities that were dealing with the use of the app. The use of the app itself is non-commercial in nature. There is a simple one-time purchase at the beginning that is a purchase of the app, not within the app, so there's no real commercial nature within that, and therefore the injury that arises out of the use of the app is not tied to the advertisement, so there's no way within the injury to tie Franklin to to tie Sue Sheff to the state of Franklin. The only nexus that could exist would be from the advertisements, and the injury is not connected to the advertisements, and so therefore that would not be able to satisfy the concepts of personal jurisdiction.
Excuse me. How would you answer to the change in the update on the mobile application that made it incompatible with screen readers as not causing the injury?
Yeah. I would respond to that, thank you, Your Honor. I would respond to that because that was something that Sue Sheff was not under an obligation to provide. So when they did not update that properly, they were not violating anything. They were originally providing a service that they were not required to provide. So when they, because the mobile application is not a place of public accommodation, so they did not have to have it accessible to visually impaired people. So going from having it accessible to not having it being accessible didn't violate anything because they were not required to in the first point. Thank you very much. Then just continuing on, the third point would be that we do not need to abandon the traditional framework in light of a new internet-based forum, and this is simply for the reasons that I've already discussed, that there have been many innovations throughout the course of our country's economic history, and we have relied on the standards set forth for those cases, and we can continue to rely on that same standard through the internet age and beyond until something completely requires an abandoning of the test, and I do not think the internet is that. Finally, in regards to personal jurisdiction, I believe that it would interfere with the traditional notions of fair play and substantial justice if we required Sue Sheff to to answer the court in exercising personal jurisdiction over them in this matter. If we were to allow the court to exercise personal jurisdiction over Sous Chef in this instance, there would be no scenario in which Sous Chef would not be accessible to being held into court throughout the entire United States. They sell, or at least coarsely provide, advertisements to all 50 states, at least in some degree, regardless of the nature of their activities within their state. And so if you're going to ask that Sous Chef be liable to be brought into court in any state within the United States, then you would be doing the same for any company that relies on the internet in any way, shape, or form, because the internet is viewable from anyone who has access to an internet connection. So anyone who posts a website or has any sort of application that has interacted with customers would be able to be hauled into court within anywhere in the United States. For example, a company in New York State who ran a business that had an application that someone in Hawaii could access, the person in Hawaii could ask that they be brought into a district court in Hawaii and be answerable there. That cannot comport to the traditional notions of fair play and justice in any way, shape, or form. As to my second point in regards to the assertion that the trial court did not err in ruling that the mobile app did not qualify as a place of public accommodation according to the Americans with Disability Act Title III, the court should uphold the trial court's decision in this area because no court has ever held that a place that did not have a brick and mortar store of some sort within the forum that you could purchase a item from could then be tied to the application and use that to center around its requirement for a place of public accommodation requirement. The application of Sous Chef has no correlation to any brick and mortar store within the state of Franklin. There is no location that exists within Franklin whatsoever where you can go and knock on a door and enter a store and purchase something. In conclusion, I would ask that the, do you have a question?
Yeah, so in some circuits, websites can be enough to get to having that public accommodation. How is a website different than a mobile application?
It's my understanding that even the websites have to be tied to some sort of either A, purchasing potential, or B, have a brick and mortar store within the jurisdiction of some degree. Thank you very much.